Here we go. Bam. Hey, everybody. It's time to get to work. First off, I want to take a few minutes and thank you guys for supporting me. Oh, you see my fancy YouTube shirt on here, Foreclosure Rescue. Yeah, we got accepted into the YouTube partnership program over the weekend or here a few days ago. And I'm pretty proud of that. I've been working on that for a while. So I had to get 1,000 subscribers and 4,000 hours of watch time. And we got that done you have to get that done within a year. And we did. Hey, Joshua, what's up? So we got those qualifications done. And now, well, when I was signing up to get accepted in the program, it said that it takes 3 weeks before you're approved. So I was like, well, I guess I can wait that long before my head gets too big. And then I got a text at like 10 after 5 in the morning. And I got to thinking, there's nobody in trouble right now who's texting me at 10 after 5. Pulled up my phone and looked at it, and it was YouTube sending me. That's the first time I was happy to get a text to get woke up at 10 after 5 in the morning. Yeah, it was YouTube. They let me know that I'd been approved and accepted in the program. And yeah, now it's time to rock and roll. And so far, I made $2.58. Hey, Rock Solid, Patricia. I see you guys. You guys are on time. That's good. So nobody has to run, even though you don't know what time I'm coming on. Hey, Kerry Jackson. So first of all, I'm thanking everybody for supporting me on YouTube because I'm a YouTube creator now. I'm partners with YouTube, and if anybody wants my autograph, I'm gonna have to charge you. Okay, well, maybe we can work something out. Nobody wants my autograph yet, right? Okay. Let me get under control. I'm really happy to be partners with YouTube now, and at some point in time, well, right now all my videos are monetized. At some point in time, we'll be rocking those ads, and when that happens, we're going to make our prices a little bit lower so we can get more people in the door. So I know I've been saying that all along. I have not forgotten what I said. I do what I say and say what I do. Yeah, my daughter told me that one day when she was in the 5th grade. She told me that she was writing her essay about me because I was like, "You're writing about me? Why are you writing about me?" She said, "Because Dad, you always say what you do and do what you say." Okay, in 5th grade. Okay, apparently we done something right. So anyway, so let's get on with what we're going to be talking about today. I picked out a nice juicy subject today that I know you guys are going to want to talk about. So today, oh yeah, I forgot to welcome you guys. Welcome to Advocates for Justice Foreclosure Defense Paralegal Service. We are different and we prove it. I'm Coach Neighbors. You guys already know that. I'm the one that get to blow the whistle up in here. And today we're going to spend a few minutes talking about these things. Number one, jurisdiction. Jurisdiction is the only thing that you should be challenging if you're in foreclosure court, really any court, because people need to understand the conventional foreclosure defense program was set up by the attorneys, the same attorneys that's trying to steal your property. So if you go into court arguing the banking stuff and doing the conventional way, you might as well just go pack your stuff, okay? Because I've been doing this for a minute and I don't see the conventional way helping anybody. And the main reason is because when you go the conventional way, it's the way attorneys want you to do. And they have a nice little game plan for you when you go down their sidewalk. Yep. Yep, they do. And I'm sure you guys figured that out. Otherwise, you wouldn't be looking at my program, which is unconventional, where we go after them for causing the problem that you're having right now. So the second thing we're going to talk about is who is supposed to prove jurisdiction? Who must prove jurisdiction? So that's kind of getting to be a little bit of a problem in the process. And we're going to talk about obstruction of the administration of justice and what that means. I had a lady ask me this past week, could the judge obstruct the administration of justice? I'm like, Thank you all day long. And fourth, we're going to talk about the requirements to recuse a judge. Yeah. So I have to be real creative with the title for this video because I found out all 125 of my videos, well, almost all of them got monetized except a couple. The ones that have the title where we're talking about suing the judge and doing stuff to the judge, um, I can't monetize those because nobody wants to advertise on how to kick the judge's butt. So we're just going to be a little creative with the title for this one so it don't become a problem. Or at least that's my plan. So requirements to recuse a judge. We're going to talk about disqualification of a judge and what you should do about the situation when you get into a situation where you need to be attacking the judge. So let's just get started. The issue of jurisdiction is the only issue that you should be discussing, that you should ever be discussing with bar members if you're in foreclosure court or fighting your house for foreclosure. Whenever they talk to you on the phone, that jurisdictional challenge with that affidavit talks about 6 things that's missing. It also talks about the fact that the foreclosure statute does not have the necessary elements to be considered a valid law. So according to your state constitution. So the foreclosure is in violation of your constitutional rights for several reasons. But you want to stick with the jurisdictional challenge. That's where you want to stick to when you're trying to address this problem, because if you don't, you will get stuck in their conventional program and they'll beat you over the head. And then they'll drag you back in the eviction court. And then you already know what happens when you get dragged in the eviction court. So because of the fact that the foreclosure defense program was structured by the attorneys, they're structured by the same attorney that's trying to steal your property. So the conventional program is not going to help anybody. You know, their system is structured for arguing, and when the arguing's done, the judge gets to help them. It's simple. That's how I see it. It's simple. I like to keep things simple. Therefore, in my program, you're going to be addressing the stuff that they don't want to talk about. Okay, they don't want to go into court and talk about the fact that the attorney is actually the plaintiff, and they lied on the paperwork and said it was a lender, but the attorney is the only one that signed any of the paperwork that's coming after your property. It ain't signed by the lender. The lender ain't signed nowhere. It's only the attorney acting as a third-party debt collector. And until you understand this, you will not be driver of the bus. Okay, so you need to understand the attorney is the one coming after you, not the lender. Man, I have so many people call me and they get so fixated on the lender, and I think part of it is the emotional part of everything. When it all starts, I think the lender's coming after you because the attorney lied. The attorneys lie. You can tell they're lying when their mouth moves. Okay, if their mouth moves, they're lying. So everything that you have been taught by the attorneys or from the system, and the system was taught by the attorneys, is a lie. And until you figure that out, you're going to be struggling. And I have people call me, and if they argue with me about that, you know, I just tell them, okay, good luck. I don't even really want to work with them because I'm going to spend too much time arguing with them, trying to convince them to do what the coach needs them to do. And I grew up in sports, and when the coach told you to do stuff, you went and got it done. We didn't have a bunch of excuses and stuff for why it can't get done or whatever. Coach ain't trying to hear none of that. That stuff you got to work out. And yeah, that's the way it rolls when you're the coach. And I told a lady the other day, you pay me to be the coach, so I'm going to be the coach. You can tell me to shut up and go sit down, and I will leave you alone. But as long as you pay me to be the coach, I don't be talking and telling you what you need to be doing or what you're not doing or what the problem is. I got no problem with that. So proof is this is the fact that attorneys proof to show the fact that attorneys are the ones that's coming after you is check the document. Check the document to see who signed it. And you know, it's really funny because if you go to sue somebody for something, you want to make sure that you get all the owners. So you're going to check and you're going to see who signed, who's the owner, But when foreclosure court, we're not doing that. We're just going after the lender, and we're assuming the lender, yeah. So people don't realize that there's two situations going on. You have the illegal mortgage fraud, and then you have the illegal foreclosure fraud. And they both have very different parties executing fraud. Most people go into foreclosure court with the wrong fraud party sticking on the foreclosure, and that's why they get thrown out of court. Because everybody in court that's a bar member knows that the lender don't have nothing to do with it, because the lender charged the stuff off of their books and wrote it off their taxes, and then they illegally sold it as an alleged debt to the third-party debt collecting attorney. And that's why we only have the attorney, the law firm, and the last servicer who sold it to the attorney as the number one defendants on the lawsuit. All those other people are just put on there to muddy the waters and confuse things. So let's keep moving forward here before I check to see if anybody has any questions. So who must prove jurisdiction? Okay, and this is a question that you need to know. If you're going to be using my jurisdictional challenge or any of the documents or my strategies, you're going to have to understand this. Who is supposed to prove jurisdiction? Well, I'm going to just tell you, okay? The party who filed the lawsuit is the one that must prove jurisdiction. And some of the people who filed the jurisdictional challenge with affidavit failed to review the federal rules of civil procedure to find out what the time frame is the attorneys have to respond. So if you don't know how long the attorneys have to respond, then you don't know when they're out of time. When they're out of time, you won't be able to default them because you don't know. So that's the number one thing that you guys need to do. If you're using my jurisdictional challenge with an affidavit, I'm going to tell you right now, they're not going to be able to respond because what they're doing is fraud, and they can't respond by counter affidavit. So what's been happening is the judge has been like responding for them, dismissing, well, in a few cases, dismissing the jurisdictional challenge with an affidavit. And that's kind of where we're heading with this live stream tonight. What you need to do about that situation. So first of all, when they fail to respond, you must file your demand for default ASAP. I mean, the actual day they're in default, you need to file that day. And there's no reason the default's in your package. There's no reason why you can't have it already to file, because I'm telling you right now, they're not going to be able to respond to the jurisdictional challenge with an affidavit. And that's what we've been using. A lot of people have been using to smack them in the face with. So in doing so, you want to make sure that you do not wait for the judge to respond or the judge to order them to respond. You don't need to wait for none of that stuff, okay? When you do that, you're letting the judge know that you're in agreement for him or her to take jurisdiction and dismiss your stuff, okay? So you don't want to wait. And if the judge steps up and dismisses your stuff for them, then you need to still file your notice of default, because the judge does this stuff all the time. They do stuff that's illegal, and then if they can get you to stand down and go sit down and shut the hell up, then they're good. So if the judge does something that if you file a document the attorney is supposed to respond to by counter affidavit, and they don't respond to it or respond by counter affidavit, I don't give a crap what the judge says. You need to be filing your demand default their butts. You know, you need to understand that in my program, we are not filing stuff on the court record waiting for the judge to respond. Okay, because that's the conventional program, and we don't do that. What you're going to be doing is you're going to be getting your stuff on the record so you can sue the judge in the end, because the judge didn't do the right thing, because the judge is not going to do the right thing. When you take my stuff to the court, they're going to have a hard time with it, and the judge is going to have to help them. And once that starts, you have to have the courage to step up and step on the judge's face, because If you don't, they're going to continue violating you. So the problem is the document must be responded to by counter affidavit by the person who filed the action, not the judge. And when the judge dismisses your jurisdictional challenge with an affidavit, the judge is violating your substantive and your procedural due process rights. And I'm going to show you guys one of my documents. I've showed it before, and I think this is like really cool to see on the jurisdictional, when we're talking about the jurisdictional challenge. Let me figure out how to do a screen share. Okay, we want to screen share one. And I'll move that out of the way. So this is what we want to look at in the screen share. So void judgments, any judgment made by a court where there was a lack of subject matter jurisdiction is called a void judgment. You guys can read that. I'm not going to read all the way through. And I'll post this, I'll copy and paste this in the comment section underneath the video when I'm all done. Now, what I want to show you guys is these subject matter jurisdictional defects are listed in most cases. And in some cases, there's several of these defects listed in one case. Now, one of these defects can be used to dismiss the foreclosure, or at least to get your evidence on the record that you need to jam the judge up in the end, because that's what it's going to come down to. What it's going to come down to is jamming up whoever it is and blocking you from getting in court. So I wanted to show these. How many of these do you think exist in your case? I had one lady told me there were like five of these jurisdictional defects in her case. So you guys can look through the ones that I have highlighted in the yellow are the ones that are the most common. And now, okay, so this one last but not least, when the rules of the circuit court are not complied with. I wonder how many of you guys have had them not comply with the rules. So yeah, this is one of my notes that I use when I'm structuring a document, and these jurisdictional defects come in very handy. So let's get back. Now I'm going to check and see who has questions. If you guys have some questions, I want to try to answer a few of them as we're going along. Patricia says, oh, she can't see it. Oh, that's her logo on her page. You might have to send her to, we're going to send you back to class, Patricia. Can you see it now? Okay, so I got 8 people watching. Who's here tonight? You guys check in so I need roll call. So I need to know who I need to make run, whoever's late. Okay, let me get back to work. So obstruction of the administration of justice. When the judge allows the attorneys a pass and assists the attorneys by providing an unfair advantage, it's time to sue the judge. I'm serious. This is the only way. At the end of the day, it doesn't matter who you sue, as long as you're going after somebody for what they're doing to you. So in the fight to keep your home, you must attack whoever is blocking you from having your day in court. Now, the question of the day, and I ask people this, and people always tell, oh, the judge has immunity. Oh, does the judge have immunity? Hell no. The judge has what is considered qualified immunity. And so what does it mean? This means that the judge has to qualify to get the immunity. So the judge has immunity as long as he qualifies. or she qualifies. To qualify for immunity, the judge has to operate within the law. Done. Judge does not have immunity. When they operate outside the law, they do not have immunity. When they ignore your stuff and don't allow the other side to respond, they do not have immunity. Now, you can believe whatever you want to, but we're got some case laws we're going to show, and I have actually several pages of case laws from the Supreme Court that supports this. The judge does not have immunity if they step outside the law. And you already know the judge is not ruling within the law because they ain't making attorneys do shit. Now, the requirements to recuse a judge. And you're probably going to be surprised that when we get to the end of this to see how much power you really do have. A judge must recuse in any proceedings in which the judge's impartiality might reasonably be questioned, or the judge has a personal bias or prejudice concerning the subject matter or a party, or the judge is a party to the proceedings. So it's easy to show the judge's impartiality is being an issue in your case because they're making you jump through these hoops and they're making attorneys do nothing. And when it comes to the documents that we have, the judge is not even allowing the attorney to respond. They want to answer for the attorney. So when the judge acts in a civil case without legal consent or jurisdiction, the judge is violated 28 U.S.C. Section 636 and the Federal Rules of Civil Procedure, Rule 73. The United States Constitution guarantees an unbiased judge who will always provide litigants with full protection of all rights. You guys let me know when you find that. Because I have not seen that. But you know what? That don't mean we can't force them to do it or push their butt in the corner and sue them if they don't. Because I'll tell you right now, these corporations do not give a crap about anything unless you can figure out a way to cost them money. You figure out a way to cost them time and money, and you'll have a chance. You won't have a chance if you can't figure out how to cost them time and money. So disqualification of a judge. The law requires the automatic disqualification of a judge is under certain circumstances. In 1994, the U.S. Supreme Court held disqualification is required if an objective observer would entertain reasonable questions about the judge's impartiality. That's it. If the judge's attitude or state of mind leads a detached observer to conclude that an unfair and impartial hearing is likely, the judge must be disqualified. Emphasis added, likely versus U.S. 114 Supreme Court. And I'll have, like I said, I'll paste these case laws in the comment section down below after the video is done and is reposted. So courts have repeatedly held that positive proof of impartiality of the judge is not a requirement. Only the appearance of impartiality. Lichtenberg versus the Health Services Acquisition Corporation. And that's a Supreme Court case law as well. Judges do not have discretion to disqualify themselves. When a judge knows he or she lacks jurisdiction or acts in the face of clearly valid statutes expressly depriving him of jurisdiction, the jurisdiction immunity is lost. Rankin versus Howard, and that's 1980, and that's also Supreme Court. So you see, we have a lot of power over the judge, but nobody exercises it because everybody's too busy with their legs shaking in court, all nervous. And the thing is, I get nervous when I go into court too. So that's not nothing that I'm laughing at anybody about. But you know what? If you're willing to do whatever it takes, after you get out of there and you find out that you got hosed, then you need to do something about it. The judge's failure to follow simple guidelines of their post and rules of law makes the judge's decisions no longer a judicial act, but an individual act that represents his own prejudice and goals. I think the goal in the foreclosure situation is to earn whatever it is they stick in your pension or something. I know they got something going on to be doing what they're doing to people. So a judge must act within his jurisdiction as subject matter and person to be entitled to immunity. And that's also a Supreme Court case law. So what do you do when the judge ain't acting right? Hang on a second. Let me get my open. Okay, got some more people here. Minka, welcome. I haven't seen you here before. John Castro, good to see you, buddy. So what do you do when a judge ain't acting right? Well, most people don't realize that the district judge hardly ever looks at your case. What happens is the clerk hands your case off to the magistrate judge. The magistrate judge doesn't have consent without, doesn't have a judicial authority without consent from all parties. And if you don't believe me, look it up. So the magistrate judge will take your case and look at it, and then the magistrate judge will decide that, well, we ain't trying to hear this mess up in here. Are you kidding me? Shoot. And they're saying that the stinking statute used for foreclosure doesn't have the necessary elements to be considered a valid law. See, we ain't trying to have that. So the magistrate judge is going to write a report to dismiss your case for failure to state a claim. And most people don't have the attorney as the number one defendant. So that failure to state a claim is real easy because you're not going to have the right person in the seat to get the claim done, to get the statement of the claim done. So when the magistrate judge looks at your stuff and decides it's too hot, then the magistrate judge will write a report, and they'll write this report to the district judge to dismiss your stuff. Now, the district judge will take all of your stuff and the magistrate judge report and dismiss your stuff based off the magistrate judge report. And if you don't believe me, pull your paperwork out and look on it. When the judge signed the thing, the judge is dismissing your stuff based off of the magistrate judge report, not his ruling and conclusions of law and facts of finding. They dismiss your stuff based off the magistrate judge report. That's administrative. So what they just did with you was drag you into their administrative hearing where you have no constitutional rights or any other rights, and they slap the shit all over you. That's what they do. That's what they do. And this is why the goal, and this is what we're finding out. I've been working with people in my Facebook page from all over the United States, from California, like John Castro, I think he's from California. Patricia Ross, I think she's in Georgia, I think. I got people in New York, and I've learned from real-time feedback from people using my products how to change things and what to do. So what we've done, when you know that your stuff just got dismissed based off of a report from the magistrate judge, and the magistrate judge don't have jurisdiction to be involved in your case without all parties' consent, written consent, man, that's a mess. So what we do is we have a motion for reconsideration. It's actually a motion for reconsideration / your notice of claim that you want to file against a judge. And so what you want to do is create the district judge in a situation where they have to do like a mini bench trial kind of a thing. So what you do is everything that you filed in court, everything, you want to take file stamp copies of everything that you filed in court that they're ignoring, and you attach them as exhibits to your motion for reconsideration. Okay, you attach them as exhibits to your motion for reconsideration, and in your motion you want to outline, well, we have this motion here that we filed on this date. See exhibit A for domain, whatever. And then, yeah, so you want to mention it in there and then connect it to the exhibits. And you want to attach file stamp copies of all the exhibits that you filed and on your motion for reconsideration and your notice of claim. The motion for reconsideration, notice of claim is one document. And when you do that, then you file for reconsideration and you attach file stamp copies of everything that you filed in the case. And then once you do that, then you can file you have the notice of claim. If you want to turn it into a claim, you can. Most of the people just file a notice of claim because their goal is to get the judge to reconsider so they can get their foot in the door and pass the first hurdle. So once you do that, then you file a motion for reconsideration and you get your notice of claim on there and all those documents in there. You want to get everything in there. Okay. Then you jam them up with your notice of appeal. Now you're doing this in state court. You want to jam them up with your notice of appeal, and once you get your notice of appeal stuck in their face, okay, now they're going to have thinking about what if all this starts heading up, or even in federal court. You can do the same thing in federal court to try to dismiss your stuff for failure to state a claim. And then once you get all these things on here showing the file stamp copies of stuff, showing what the judges ignored, now you're ready to file your appeal and force the judge to have to force the judge have to respond to the appellate court when they can see all of the dirt that they're doing. So that's how we get around that. And in the process, if the judge is throwing you under the bus in the process, then you will need to file your claim against the judge, because you're going to need to attack anybody that's blocking you from getting in court. So John Castro said he had the attorneys in the number one position, so they gave him a chance to amend it, and then they dismissed it. Well, right. So, John, you amended it and moved the attorneys, and if they dismissed it, then if they dismiss your stuff, you are supposed to respond to it, object to their dismissal, and point out why they shouldn't have dismissed it, and then file your notice of appeal, and then you need to file against the judge if the judge is out of line. But people need to understand that if the attorneys file something and dismiss under Rule 12B for failure to state a claim, you get a chance to respond to it. You shouldn't just sit back and not reply and then be grumpy later. You have to respond to whatever it is they file. You get a chance to reply to their response to your document. And if they move to dismiss, then you need to object to it and put in there why. Most people think that once the judge says it's done, that's a wrap, and they go sit down and give up. No, hell no. The judge is a bar member just like them, and just like the attorneys. And most people, by the time you find me, realize that they're all working together. So that's how we roll on that. So the motion for reconsideration is on my website. I've included it in the packages right now in the judicial and the non-judicial package, but it's also on my website because that document can be used even if you're not in foreclosure. If you get kicked out of court for whatever, you can still use that document. You'll just have to personalize it to make it fit for your situation, but that should not be a problem for you. So that's the main thing I wanted to talk about with that. And the jurisdictional challenge with an affidavit has been doing great. Joshua invested in our marriage dissolution document, and he's getting ready to use that. So I'm excited to see how that goes for him, so he can report back to the group and let everybody know. So when you guys invest in my documents, I would appreciate it if you guys will leave me a review. Now, I'm asking for a review on the content of what you invested in. After you review the package, do you feel like the package has value for you? That's what I'm asking, because I want other people to see. If I have to wait until you win or lose, then all these people are going to miss out on seeing that you have opportunity here. Because in my program, it's not winning or losing. Okay, in my program, what it comes down, because winning and losing means that the judge is going to give you everything. Well, that shit ain't never going to happen. Okay, and my program is going to come down to making the attorney go sit down and shut up. Okay, and leave people alone. That's what it's going to come down to. And when it comes down to that, the attorneys are going to make you sign a non-disclosure statement, so other people can't find out that you just smacked them in their face. So all the people that sit around waiting to see how many wins, those people need to just start packing. I'm just saying, because it's not about winning. You're not going to see a win because of the fraud. And if you back them in the corner and make them sit the hell down, they're going to make you sign a non-disclosure statement. And and so I have people that they're like, dude, I just tell them, look, I don't care about I don't care that you can't, it'd be nice to get a review in the beginning that the documents were like, have value, and that you're going to do a follow-up later. And if you don't do the follow-up later, that's fine, because I get it. I don't expect to have everybody do all of these things, and I'm not trying to prove to everybody that all this stuff, because I don't have time. I have plenty of people that are smart enough to listen to what I've got to say and study the videos and compare them to the situation they're in. They're plenty smart enough to figure out that my program has value. So, and you guys will probably know that I don't push people to get in my program. So I don't even push, because my program's not for everybody. And it takes a lot of time and studying to be able to do this. People call me and ask me, dude, I'm not an attorney. You got to do that homework yourself. You got to figure that out. My job is to coach you, to give you the strategies, to put you in position, and then you got to do the rest. So, and I tell people all the time, people call me and ask me, hey, do I have this document in my package? Okay, I don't know what package you got, number one. Number two, my job is not to make it easy for you. So I tell you, go check your package. It's what you should have been doing in the first place before you called me. So that's pretty important. So welcome, James Galley. And James Galley, he agrees. It's not the winning. It's getting to stay in your house. That's our goal. Our goal is to help you is to teach you how to stay in your house and get what you need on the record for your lawsuit against the judge, because that's what it's going to come down to. And my program is going to come down to the judge helping them, and you're going to have to do something about it. So if you're willing to do whatever it takes, my program is badass. If you're not willing to do whatever it takes, you probably should go and find an attorney. I can't believe I said that, but I did. Hey, Ricky, how you doing, man? Ricky says, if the attorney had a witness in court, did that give them jurisdiction? So, Ricky, I'm going to say that's a no, because whoever the attorney had in court was probably another attorney from his law firm. And if you ask for his name and ask for his card, you will see that he's probably another attorney from a law firm. So, Ricky, here's the deal. Okay. On the lawsuit, on the document that they use to initiate the lawsuit against your property, check it. It's only signed by one person, the attorney. That's it. I can tell you right now, it ain't signed by nobody from the bank. So anybody that shows up saying they're from the bank, they're full of crap. And that person that's showing up would have to fill out an affidavit. And in that affidavit, they would have to be able to prove that they were around and were working there and saw you sign the paperwork. That's not the way their affidavits go anyway. Most people don't realize that the foreclosure that's used against them is brought forward with a fraudulent affidavit, because the affidavit usually says something like, I'm attesting to the records. That's what it usually says. Well, Ricky, I know they said it was the assistant of the vice president of the bank. Right. And what does that mean to me? So I'm going to tell you a little secret. The best way to tell when an attorney's lying is to check and see if his mouth is moving. And even if there was an assistant, the attorney is still helping them. So the attorney is liable for your damages too. So And my online course, I think we have 14 people enrolled in my online course, and I'm hoping to get a review from somebody that's in the online course, um, attesting to the strength of the curriculum in the course, but I haven't got it yet. So and the online course is actually structured to help people who are investors who have real properties and stuff, because the way things are going now, especially if they shut things down again, like they're doing with the new public president, yeah, it's going to be a problem. So you guys need to consider that if you've got real properties and stuff that you're going to need to protect, the online course has everything in it. So if you enroll in the online course, it's half price right now for $1,200, and I just added last month. I added 7 new lectures, and the newest lecture that I added was the lecture on how to state a claim for relief. Now, I also did a couple of videos on that, and I will tell you guys that are doing this yourself, you need to study that video on how to state a claim for relief. Now, I didn't really use it before because all of the facts that I have in my documents outweigh that, but there's been a few people who the judge stuck that up in their face and was trying to, jam them out with that. So I was like, what the hell? So now we learned how to state the claim for relief, just like the attorneys do. And I did a couple of videos on it, and I also have a guide sheet that you will use while you're writing up the state of the claim according to the way they want it, so that you can make sure that you have it set up the way it's supposed to be, so they can't be sticking that in your face. So that's all I've got tonight, guys, and I'm going to let you guys go. I will be back here. I think I'm going to try to stream again on Wednesday night. I'm not doing the radio show anymore. Once I got monetized on YouTube here, I still have a bunch of stuff that I'm trying to learn so that I can keep up, because I ain't trying to leave no money on the table for YouTube. I'll take what they give me. I'm not trying to leave nothing extra on the table. So I need to figure out how this all works, and that's what I'm working on now. I'm also working on a new lawsuit against the judge for ignoring the jurisdictional challenge with an affidavit, and that lawsuit is going to be in the online course. So the online course has stuff in it that the lawsuit packages don't have, because well, several things, and one, it's more pricey, so I need to make sure that it was worth it, that it had additional value, and so that's why that is the difference. So thank you guys for watching tonight. I will see you guys Wednesday night around the same time. I can't get it right on the money because my phone rings a lot. And the other thing I wanted to talk to you guys also, please make sure you subscribe and ring the bell so that you get notifications when it's time for class to start. Ashmeen, hey, how are you doing? So if you guys have questions, I am requiring that you ask me the questions in the Facebook group, or message me a private message on Facebook. And the reason we're doing that is because I'm too busy to answer everybody's phone calls individually. When you have a question, if you ask it in the group, everybody in the group will get to see the answer. And that's the way we need to go with this, to create this group that eventually will be able to help each other. Okay, because at some point in time, other people will know the question, or whatever, and they'll be able to help out with the answer. I don't have time to take everybody's phone calls and the new phone calls that are coming in and get stuff done. So if you call me and I text you back and ask you what you need, just text me, have a question about this, or here's my question. That would be the best thing. Here's my question. My question is blah, 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 blah. Okay. Because what I'm finding, and no offense to anybody, but most of the time I don't need to call you. A lot of the times I'm telling you to go and find it because it's within your reach, because it's not my job to make it easy for you. I'm just saying. But that's how I'm going to do this, because that's the only way that I can get things done. Now, I want the group to be able to support itself, and that's the goal behind in the group. Now, if it's personal or private, you can send me a private message and we can talk about it that way. I get that, but it's a lot easier. Now, if you email me, I don't check my emails until later at night, and sometimes not till the next day, depending on how busy I am. And so that's something that I wanted to throw on the table too. Because you email me and then people get mad because I don't have time to email them. Well, the best time to catch me is in the group and or to leave a message, tag me in a message. And as soon as I turn on the computer, that's the first thing I check. And it's a lot easier for me to respond to that on the computer than it is for me to shut my computer down and then message and then send people someone a text message because I'm like 6'7". Okay, I'm pretty big, and even though my phone's a good sized phone, those little thinking letters are really small that I have to punch. And sometimes people get my text messages and they think I'm crazy. That's because those other numbers get punched while I'm trying to punch this stuff in. So it just takes me forever. So that's how I'm going to do it. So you guys will need to catch me in the group, or or if it's not real important, you can send me an email and I'll get to it. Now, if you call me and I don't answer, you should leave me a text message. Okay. If you leave me a voicemail message, I probably will never get it because I get a lot of voicemail messages. I get a lot of stinking spam calls from people trying to sell me a warranty for my truck that's 22 years old. Yeah, they usually hang up when I tell them my truck is a 2000, and they get mad and hang up. But they keep calling me the hell back. Anyway, good night, you guys, and I'll see you guys Wednesday. If you have any questions, hit me up in the group, and make sure you're asking me questions that you don't know the answers to, because I don't like to answer questions in the group that you already know the answers to, because now we're using my time that I could be using to go give me a glass of wine or something. All right, you guys see how it goes. I'm trying to learn how to be efficient with my time and your time. So that's what we're trying to do. So thank you guys, and good night all.